Welcome back. You're watching To The Point. The Cabinet's decision to amend the Juvenile Justice Act to permit 16 to 18-year-olds to be tried as adults has received a sharply polarized response. There are many who believe this is the right step and that as far as heinous crimes are concerned, the argument the accused is a minor is irrelevant. On the other hand, the opposition is equally convinced this breaches fundamental principles and is unjustified by the known facts. With me to discuss this issue is the leading prosecutor for the Delhi Police, Richa Kapoor, former chairperson of the Delhi Commission for the Protection of Child Rights, Amod Kant, former Law Minister and Congress MP Veerappa Moily, and BJP spokesperson Juvenile Justice Act. Richa Kapoor, you're in favour and you support the amendment to the Juvenile Justice Act, which permits the trial of 16 to 18-year-olds who've committed heinous crimes under the Indian Penal Code rather than under the old Juvenile Justice Act terms. Why do you support this amendment?
See, this amendment, which has brought the age limit of 16 to 18, the amendment is only to assess by the judiciary whether the crime committed is as a crime of a child or of an adult. So it does not wash away any of the things.
That assessment is not by the judiciary.
It is by the Juvenile Justice Board.
Precisely. So they may not be applying judicial scrutiny because it will also consist of social experts and psychologists.
Yes, so that is good. So they will have psychologists, social experts.
So you support it for that reason?
Yes, why not? It does not limit the age. It just deals with the juveniles with criminal mindset. And it...
Well, it does, because you're assuming that the quality of the assessment will be such as to be indisputable. In India, such assessments can often go awry.
No, they will send it to the children's court, who will determine whether the crime committed is a crime of a child.
So you're satisfied that juvenile rights are protected by this amendment? They're not breached?
It will certainly prevent the misuse of the law.
Amod Kant, you're against the amendment and you believe that at no cost should the age of juvenile be reduced below 18. What's your main argument for opposing this amendment?
First of all, I'm not the most knowledgeable person. Far more knowledgeable than me was the Supreme Court of India. This matter is being debated in the Honorable Supreme Court of India. You know, two very, very historic judgments. I think my lawyer friend will agree with me. Salil Bali versus Union of India, Subramaniam Swamy versus Union of India. In both the judgments, the Supreme Court of India went in great detail on this entire issue and found no justification for this change.
But except for the fact you're quoting the Supreme Court, and today's Times of India says that on the 6th of April this year, which is just over 2 weeks ago, the court asked the government to revisit the law.
Yes.
And the court said, can I quote the court? Because you're
no, I know, I'm aware.
But the audience is not. The audience will be misled by what you're saying, which is why I'm correcting it.
I have not
the court said, in cases of rape, dacoity, murder, which are heinous crimes, it's extremely difficult to conceive that the juvenile was not aware of the consequences.
If I'm
so
allowed
come back to me. Why are you opposing this? Give me your reasons for opposing it.
I'm giving reasons. See, I had just quoted Supreme Court of India.
But give me your reason, because we run out of time.
Parliamentary Standing Committee said the same thing. Verma Committee said the same thing. Now, first of all, just one or two very small points, the basic points. Why I'm opposing this entire amendment. Number one, a person acquires various rights. Right to legal action, right to marry, right to own property, right to even engage a lawyer, everything else. I think she'll know better. At the age of 18 years. Now you are trying to put that person into dock, you are trying to put the person in ordinary court, ordinary jail, ordinary police process, through investigation, through lockup, through handcuff, everything else at the age of 16, without giving those rights to him. I mean, the rights are
so in other words, this is out of sync with all the other rights that come only after 18.
I mean, all the laws, 18 years is the age.
Is that your main reason for opposing it?
No, this is one.
No, give me your main reason, because we can't go on for too long.
I'm giving it. The whole thing, the entire...
What's your main reason?
There is no ground for it. There is no ground for it. I mean, in India, let me clarify, the total number of crimes committed by children is just about 1.5%. The heinous crimes, among the adult heinous crimes, it comes to hardly 3%. Let me clarify. And then there is no ground for that.
Let me put that point. Let me stop you there. Let me put that point to Mr. Narasimha Rao, who comes to us on behalf of the BJP as their spokesperson. What you're hearing, in fact, from Mr. Amod Kant is that there are no facts that justify the amendment. He says that in the year 2013-14, there were 1,69,376 heinous crimes committed in India, of which only 5,901 which is 3.4%, were committed by juveniles. Clearly, if those facts are correct, and those are national facts, there is no case for this amendment.
They constitute 40%.
Let's answer it. Mr. Narasimha Rao.
Even if I even if I accept these numbers and all the victims in those cases, don't they have a right to life? Don't they have a right to live dignified life? How should one in heinous crimes? I think how should children in that age group be not treated as adults, because the nature of the crime committed is something that is generally associated with adult years. Therefore, I think there is a clamor. I think even the Supreme Court is seized of the issue. This is an issue where I think the Parliament hopefully will be able to come together and unanimously discuss and then debate a bill like this, threadbare, and then pass the bill in such a manner that people who are actually victims in such cases actually derive justice. If there are only a few children who commit such crimes, only they will be punished.
Let me bring in Mr. Moily.
To punish all the children.
Mr. Moily, the argument presented by Mr. Narasimha Rao began by talking about the clamour for justice from the families as well as the victim himself of such horrible, heinous crimes. And in fact, the motivating factor is the horrible Nirbhay case which happened when you were in power. In that instance, one of the guilty, and many believe the most brutal, was a minor. Yet at the end of the day, he got away with just 3 years detention in a correction home. And people say that A, that's inadequate punishment, and B, he was clearly old enough to know the consequences of the horrible act he inflicted on Nirbhay. Do you think that's a good motivation for changing the law, or do you think it's an inadequate one?
You know, the present amendment, which is sought to be brought about by the government, is totally opposed to the philosophy of criminal justice system. You know, it is not that I am telling you, even the UN Charter, you know, of which India is a party and signatory, you know, they also said, you know, juvenile means what it is, 16 to 18 years, that is defined, and you know, you will have to treat them equal. And this is the charter. You know, if they want to change the law today, I think they will have to withdraw from the signature which they have already given.
Can I stop you there? Can I stop you there? Mr. Yes. Moily, you're quoting the UN Charter on Child Rights, and you're saying that under that charter, to which India is a signatory, the cutoff age for juveniles is 18, and if we lower it to 16, we'll have to opt out of the charter. But the truth is that the United Kingdom and the United States are also signatories to that charter, and their laws do make provisions, fairly ample provisions by the way, for minors to be tried as adults. Now, they haven't opted out of the charter as a result, so why would we have to opt out? If they, let Mr. Moily answer it, then I'll come to you.
They are not good models. They are not good models. In fact, you know, you will have to be a model. You know, you are not just imitating UK and other countries. Apart from that, Justice J.S. Verma has gone into this particular rape which was committed here, and also other matter, heinous crimes. You know, that he has also dealt with that, but you know, he never recommended this.
True.
One instance of Delhi rape cannot change the philosophy of the law, the core principles of the law.
I cannot. One at a time. I'll come first to.
Go by emotions.
Mr. Khan, please hold yourself. You're interrupting people.
And it is not meant for one case.
Okay.
One case, if you want to do it, that is a different matter.
I take your point, Mr. Moily. Let me put your argument to Richa Kapoor, who's a proponent.
Accommodate one case.
Let me put your point, Mr. Moily, to Richa Kapoor, who's a proponent of this amendment. Then I'll come to Mr. Kant, who's an opponent of it. To be motivated to change the law on the basis of just one horrible incident Nirbhay is to actually make a mockery of the basis on which jurisprudence is written. It is a bad law if it's motivated by one instance. Surely, changes in the law should be a result of a higher principle of jurisprudence. That higher principle is missing in this instance.
No, it's wrong. See, 3 principles of juvenile justice are: 1, the presumption in the favor of a child that he is innocent. 2nd, that all decisions taken are in the interest of child. And third is that institutionalization has to be resorted as a last resort. All those principles are maintained by this amendment. What are they doing with this amendment?
Can I interrupt you there? It's not just the UN Charter on Child Rights that could be flouted. Many people believe that Article 14 of the Indian Constitution, which ensures equality before the law, is being flouted, because hereafter, some people in the age group 16 to 18 will be treated differently to others depending on what assessment is made by the Juvenile Justice Board. And as I said earlier, who knows how good that assessment will be. In India, we have to assume that such assessments are usually flawed.
Yes.
So then clearly you're breaching Article 14 as well.
No, that is an argument which will be debated upon, but the point is that it is what it is doing. This is only assessing the mental and physical capacities and trying to assess whether the child had an understanding of the consequences.
But on the outcome of that assessment will depend the nature of the justice that applies, and therefore you will be differentiating between some 16 to 18-year-olds and others. And that is unfair. Let me bring you in, because I want to follow on that point in the sense in which Richa Kapoor was first arguing it. She says this fulfills jurisprudential principle requirements because there is an assessment that will happen. That assessment will determine whether this minor should be treated as a minor and tried by a judicial authority that is for young people, or whether he should be treated as an adult and tried in a proper court. Let me put that question to him. Why do you believe that two-stage process, first an assessment, then a trial, is not adequately protecting the rights of juveniles? Why do you believe that is the case?
See this act, as I have known it, it flouts all possible principles of juvenile justice. See, first of all, the time being given under the law
but first
is only
answer my question before you jump to other things, Mr. Kant. Why do you believe that two-stage process is inadequate?
That's the point I'm trying to say. See, the time being given, there are two issues here, three issues involved. Number one, let me correct the position. United Nations is not a signatory to
Please answer this question before we go to the UN, otherwise we'll get confused.
No, because see, that
stick
point
to this,
was
Mr. Kant, otherwise we won't know what we're talking about. So please stick to this issue.
Which issue?
You've forgotten. The issue is a very simple one. It's the point that Richa Kapoor made, that this is a two-stage process. First an assessment. That assessment will decide whether the child committed it as a child without knowing the consequences, or whether the child should be deemed an adult. Thereafter comes a trial. She says that two-stage process guarantees juvenile rights are protected.
And it does
Why do you, let her answer. Why do you believe that's not an adequate protection?
Two-stage process that she is talking about, the first stage is said to be a preliminary inquiry, which is about just 1 month. Now, within 1 month, the court is being asked to, the Juvenile Justice Board is being asked to conduct a preliminary inquiry. And that preliminary inquiry means that entire evidence, everything else should come within 1 month. And 1 month is too inadequate time to find out about it. That's very important.
So you agree that this assessment will be inadequate?
Secondly, assessment apart. Now the age is a factor you mentioned about. You talked about 16 to 18 years. Now it is established beyond doubt that a child is immature, that our child is not able to understand the consequences till the age of 18 years. Even Supreme Court of India have cited numerous instances and studies about it.
No, but hang on a second. You keep talking about the Supreme Court. I want to quote you yet again what the Supreme Court said on the 6th of April. That's just over 2 weeks ago.
No, it is not judgment. No, please.
I know it's not a judgment.
It's an observation.
Absolutely.
Observations don't become judgment.
Just a moment, it's an observation by judges.
It doesn't mean anything.
But hang on a moment.
It doesn't mean anything.
Hang on a moment. It is an observation to back up their request to the government to revisit the law.
No.
Are you saying those judges were simply making comments without understanding what they were saying?
Decidedly against the kind of judgment which I am referring to.
Right.
They are full-scale judgments.
Let me bring in Mr. Moily on that point, because Mr. Moily, you've been law minister, you've been a lawyer yourself. You know the difference between observations and judgments. No one's claiming this is a judgment, but it's an observation made by the Supreme Court on the 6th of April, just over 2 weeks ago, when they specifically asked the government to revisit this law. And what they said was, and I'm quoting it again, in cases of rape, dacoity, murder, which are heinous crimes, it's extremely difficult to conceive that the juvenile was not aware of the consequences. And what they're saying is that when a 16 to 18-year-old murders or rapes, you can't argue that he didn't know what he was doing and therefore should be treated like a child. Do you accept that observation as a logical one and a good reason to change the law, or do you think, like Mr. Kant, this is just a stray comment made by a judge, don't take it seriously?
Just like you and me, the judges also differ. You know, Justice Sathashivam spoke vehemently against it, against changing it. And he has maintained that juvenile is a juvenile, and you cannot, judge them, matter. Judgment is a matter of degree. So, of course, Justice Deepak Mishra has given a different, of course, he has written this judgment. That means to say, even the Supreme Court is not united on this, they differ from one judgment to another judgment.
So your conclusion is don't take this observation seriously. So your conclusion is don't take this observation.
Yeah, that is it. That's it. Another point is in the highest body like this Parliament, Parliamentary Standing Committee, they also give a report against it. And whatever UN Charter is against
but governments often overturn Parliamentary Standing Committee reports.
Standing Committee is against it. And
it's a very comprehensive report, a very good report.
But Standing Committee is often overturned by governments.
So that apart,
how do you deprive of the juvenile justice to the juvenile people?
Mr. Narasimha Rao, let me point out an inconsistency or an anomaly in the way your government is approaching this matter. The amended Juvenile Justice Act exempts underage offenders from the death sentence or a life term. Now, the question I want to put to you is this. If you believe that minors should be tried as adults for heinous crimes, why then should they not get the same punishment as adults? It's very strange to say minors should be tried as adults for heinous crimes, but when it comes to punishment after they're found guilty, they go back to being minors and they're exempted from the death penalty and the life sentence. That's an inconsistency that suggests to me either you haven't thought through this amendment carefully enough, or having done it, you're not totally convinced you're doing the right thing, so you're leaving an escape clause at the end because you have doubts in your own mind about it.
Karan, I think an issue like this is a very, very sensitive issue. This no government, I think no government can be all can have all the wisdom in the world. I think the government in its wisdom thinks, I think while treating them and handing them punishment as adults, you also need to give some kind of a possibly show a sense of humanity while even handing out punishment. This is one way of looking at it.
But this is very interesting. You show the humanity, as you call it, when it comes to the question of punishment. You don't show that humanity in the instance of the trial. That's the inconsistency I'm pointing out. And it suggests to me either the government hasn't thought through the matter, or it's not convinced of the amendment it's pushing, which is why it's left this halfway house. You oppose this, Mr. Kant. Let me put this to you. How do you intend to take further your opposition? Because now that the cabinet has cleared it and the government has a majority in the Lok Sabha, I presume it will go through. And because this is so popular with many political parties, it will probably go through the Rajya Sabha. So how will you oppose this?
We have been approaching, we have been writing to the members of parliament, we have been writing to the ministers, we have met them also to convince the point. Well, cabinet has approved it. Now, there are very, very serious contradictions. Very serious contradictions. One of them you pointed out already.
Contradictions. Tell me how you will pursue this opposition.
Ultimately, I mean, I can't declare it now, but decidedly, I think the way this bill has been drafted, I think there are the basic contradictions and inherent fallacies in this particular law is going to be ultimately challenged. I can give one small instance.
In a court?
Yes, in a court
also.
So
your final hope is that if passed, these amendments will be challenged in court, and the court will strike them down.
Can I possibly, if you permit me, one or two small points which I can point out. For instance, the section 341, and she would know better, section 360, 361 of the CRPC, read with Prohibition of Offenders Act, actually it prohibits the court. It says that the court should not punish the first offenders, the court should not punish the young offenders up to the age of 21 years. That is one part of it. Now, here the case of children. Here the case of children. I mean, the children who are less than 18 years of age, and you want to punish them despite this kind of other law which is meant for adults, young offenders. Second point is that the other point I'm
interrupting you. What gives you the confidence that the courts will strike down these amendments?
No, because there are contradictions. We find clear contradictions.
These are the sort of contradictions.
Other contradictions also. The basic principles which were not part of law.
Let's not get lost in detail, Mr. Kant. You are a master of detail. Unfortunately, the audience is not. The point I want to underline is that you're confident that these amendments, if challenged in court, will be struck down. Am I right in that?
Exactly.
Let me come to you. You're a lawyer too. Do you believe the courts will strike this down?
No, it is passed and it is a very fair legislation, and it does not violate any of the fundamental rights, and it is a very valid legislation. See, this
And if such legislation with such amendments can exist legally in the UK and US,
Yes,
and
why
there's a
not?
lot of the UK legal system that we accept, presumably that's a reason for believing it will be acceptable here.
I have a very valid question to be asked to Mr. Moily. If Al-Qaeda tomorrow asks for recruiting Indians, so should we not have equipped with some law which should deal with strict hand?
I think, forgive me, Richa Kapoor, you're going from the sublime, and I'm only using a simile, it's not being rude, to the ridiculous if you bring Al-Qaeda into this.
No, I'm
It has
saying, say
absolutely
tomorrow,
nothing
if
to
they
do with it.
recruits between 17 to 18.
We're not talking about a law being created to prevent Indians being
I'm
recruited
saying,
by Al-Qaeda.
and it also
I think
It also
you're
prevents the
reducing
children from
your
exploitation.
advocacy of these amendments to the ridiculous by bringing in Al-Qaeda. Let's leave it there. You had a very good case. Don't spoil it
that
by
is
bringing
right.
in Al-Qaeda.
But it
Don't
also
spoil
prevents,
your own
all
case.
right, let us forget that. It
We're
also
out of time.
prevents, yes, it also prevents from exploitation at hands of the criminal gangs who use these minors, knowing that one day less than 18.
Forgive me. I think you're adding in over here motivations to advocate and justify the law, which probably weren't intended. Let's stick to the basics, which is many people believe that when a 16 or a 17-year-old rapes and murders, he or she knows what they're doing. They can't claim they were children. On the other hand, the principle of jurisprudence should not be changed simply because you've had one horrible example like Nirbhay. Higher principles should apply to our law. One example should never be the motivation for changing the law. There's a real conflict here, and let's hope the government has thought it through carefully. Let's hope our parliament thinks it through carefully before they pass into law the changes that are intended. My thanks to all my guests for joining me. This is a complicated subject. It's not an easy one to understand, but it is critical because we all will have children who are between 16 and 18 and who, God forbid, should do something silly, could be liable to the new law. And it's something that all parents would care deeply about. Thanks for watching. Goodbye. Good night.